Hello, good morning. Ladies and gentlemen, ako po si Atty. Toto. Mag-vlog po tayo ngayon at ang ating topic ay yung pagkukonvict ng Court of Appeals kay Maria Ressa ng Rappler na isang Nobel laureate at sa kanyang reporter na si Reynaldo Santos Jr. All I want to say is that this is my opinion and this is my dissenting opinion against the decision of the Court of Appeals in affirming the conviction by the Regional Trial Court of Manila of Maria Ressa and her reporter Reynaldo Santos Jr. on the story entitled CG or Chief Justice using SUVs of controversial quote-unquote businessman. And this controversial businessman was named later as William King. So I have been arguing that there is no libel in this case. Now I will limit my discussion only on the particular application by the Court of Appeals and the Regional Trial Court of Manila of the so-called multiple publication rule, or the rule that in their own narrow definition refers to in every publication there is always one and separate libel. I am disheartened. I am ashamed of what was done by the Court of Appeals because this Court of Appeals, every Court of Appeals division represents what is the justice system of the Philippines to the entire world. Their decision reflects their either incompetence or their, shall I call, intelligence or excellence in the judicial analysis of any case. I want to shout out to Rafi Dizon. I thank you for your salute. But anyway, before I proceed, let me ask support from my friends. Please share this live video in order for many Filipinos to know the correct definition of what is multiple publication rule as wrongly applied to the Court of Appeals that resulted in their decision to affirm the conviction by the Regional Trial in Manila of Maria Ressa and Reynaldo Santos. Okay, let us start. I call it as a forbidden sin of the Court of Appeals in applying multiple publication rule to convict Maria Ressa and Reynaldo Santos Jr. You know, the Court of Appeals committed a forbidden sin of wrong application on the multiple publication rule as I analyzed the following. Number one, it is because of the unforgivable mistake the Court of Appeals concluded that Maria Ressa and the reporter Reynaldo Santos are guilty of libel because they were considered under the multiple publication rule as having committed a separate act of publishing that in-depth news item that was already published earlier. By the way, this article in question was first published on the website of Rappler.com on May 29, 2012, entitled CG using SUVs of controversial businessman. It is where Rappler described the businessman named William King as having shady past, based on intelligence report. On May 29, 2012, there was no law yet that imprisoned posting of libel posts on Facebook or any other online platforms. By the way, what really led the RTC of Manila to convict Maria Ressa and Reynaldo Santos Jr. is actually the fact that Maria Ressa and Reynaldo Santos Jr. failed to present in court the evidence or the document that they called intelligence report. In other words, after the presentation of their defense, they lack one defense evidence, which is supposed to be the intelligence report. And that intelligence report, by the absence of it, resulted in the RTC of Manila in convicting Maria Ressa and Reynaldo Santos Jr. On 12 September 2012, the cybercrime law was signed by then President Noynoy Aquino. It became effective on 9 October 2012 after 15 days from publication. On October 9, 2012, the Supreme Court issued a temporary restraining order due to cases filed by the petitioners, and one of those petitioners was me. I filed it along with Percy Lapid, along with Jerry Yap. Both of them are now in heaven. Because of the petitions that we filed, the Supreme Court extended the TRO on 5 February 2013 until further orders from the court. So meaning to say, the Supreme Court found sufficient basis for our petitions of what we call, or what was called by Miriam Defensor Santiago as facial challenge on the law that was made by the Senate and the House of Representatives. By the way, on 11 February 2014, the Supreme Court issued its decision and it affirmed the constitutionality of the cybercrime law, and among them was the cybercrime law. By the way, cybercrime, as defined by the Republic Act 10175, is actually the same as it is defined in the revised penal codes, Article 353 and Article 355. So which says that the Cyberlibel law, as defined under Republic Act 10175, also has the same elements as the libel law under Republic Act or revised penal code. And the four elements are: number one, defamatory imputation; number two, identification of the person being defamed; number three, malice in making the defamation; number four, publication. Now, when it comes to cyberlibel law, the use of internet is an aggravating circumstance that, according to law, will raise by 1 degree the punishment on the one who committed the libel through internet. So that is it.
Ayon sa itinalaga ng batas.
Anyway, there is a...
Ano hindi ko maintindihan kasi dito sa raptor na ito, mga kapatid natin. Ano, pag si BBM,
Okay.
the son of a dictator, di ba? Pero lagi, yung mga nakalagay doon, alam nyo, it's confirmed naman na talagang itong si...
Ito, this is the interference.
Bias media. Tignan nyo, sa bawat pangalan na may...
Okay, I already switched off the interference. But anyway, let us proceed. The petitioners filed their motion reconsideration for away, including me, so that we do believe that the TRO was extended until after the date of February 19, 2014. On February 19, 2014, it is a crucial date. Rappler corrected the spelling of the word evasion because in their original posting, in that news story entitled CG using SUVs of controversial businessman, they spelled evasion as E-V-A-T-I-O-N. And the correct spelling should be E-V-A-S-I-O-N. So, meaning to say, all the words in that particular news story published on Rappler.com by Rappler are the same except for one word. In the old post, the word evasion was spelled as E-V-A-T-I-O-N. But in the new post that was posted on February 19, 2014, already at a time when the law called cybercrime law was already signed by Noynoy Aquino into law. So meaning to say, in the first publication of Rappler on Rappler.com of the same story, it was done on 29 May 2012, when there was no law yet about cyberlibel law. And to our school of law, it says that when there is no law punishing it, then it is not a crime. And we call it nullium crimen, nullia pena sine lege. It is not a crime when there is no law punishing it. So but the problem with the Maria Ressa and Reynaldo Santos, they corrected the spelling of the word evasion, and one of the most disheartening acts or incidents that happened was that the RTC and the Court of Appeals now considered that act of correcting the spelling and then reposting it as an act of publishing, which is a separate act of libel, according to them. Now, I will argue it as a very wrong or a very big mistake or as a forbidden sin. Why it is forbidden sin? Because you are imprisoning a person who is innocent. So, let's go. So, why? I will now discuss. So, if only there is no republication, let me just stress, Maria Ressa and Reynaldo Santos Jr. could have not been convicted because they posted the same article entitled CG using SUVs of controversial businessman on 29 May 2012 when there was no law of cyberlibel yet. But after the law became effective on September 12, 2012, they corrected the spelling of the word evasion, A-V-A-T-I-O-N, which is not a word because there is no such word in English language, to correct it into evasion, E-V-A-S-I-O-N. Now, it was that the correction was done on 19 February 2014, already after the law on cyberlibel was signed. Now, let us know, what is multiplication publication rule? To me, and I insist, without fear of contradiction to anybody, that multiple publication rule does not apply. It does not apply. I repeat, multiple publication rule does not apply in the case of Maria Ressa and Reynaldo Santos Jr. in relation to the story that was published by them about the impeachment trial of Renato Corona in relation to the SUVs or sport utility vehicles that were allegedly used by CG Corona as being owned then by William King, a businessman. Okay, here is it. Why is it that multiple publication rule does not apply? And if it does not apply, then it is solid as a rock that there is no republication, and if there is no republication, Maria Ressa and Reynaldo Santos Jr. must be acquitted, and there is no other way. And I do believe the Supreme Court, when this case reaches the Supreme Court, it will be favored that there is no republication that occurred with the correction only of the one word, evasion, A-V-A-T-I-O-N, into evasion, A-V-A-S-I-O-N. Now, the reasons are, number one, the first version of the article, I repeat, is the same as the second version. After they corrected the word evasion, A-V-T-I-O-N, with the word evasion, A-V-A-S-I-O-N, there is no difference between the two sentences. Thousands of sentences, thousands of words, except only for that spelling. And the spelling of evasion, which was T, was clearly meant by Maria Ressa, Rappler, and Reynaldo Santos as meaning to the word evasion, which is iniiwasan ko sa Tagalog. So that if it was changed, then that it is unfortunate that the Court of Appeals and the RTC deemed it as libelous when it was republished with just the correction of the word evasion, T with T, spelled as T or E-V-A-T-I-O-N, with the word evasion, A-V-A-S-I-O-N. to my mind, both, although wrong in spelling and there is no evasion with letter T in the English language, but the substantial effect is that they mean the same thing, evasion, pag-iiwas. Number two, the case that was cited by the Court of Appeals in convicting Maria Ressa was the case decided by the Supreme Court in Marcelo Soriano versus Ayak or Intermediate Appellate Court. And that case was about a publication of more than one weekly newspapers. So meaning to say, there was that one press release that was distributed by the author, and many newspapers published the same press release without correcting as is. They published it as is. So meaning to say, when it was published in Manila Bulletin, the same set of words were published in Inquirer, and the same set of words were published in Tribune or Manila Standard today. So that was the case, although the weekly newspapers that were used then were the weekly newspapers in Tacloban City and the weekly newspaper named The Guardian in Quezon City, which was edited by my former boss, Bobby de la Cruz. In that case, Bobby de la Cruz and his companion editors, Marcelo Soriano, Cesar Montujo, Emmanuel Veloso, Valinda Quintero, were having their offices in Quezon City, and they were charged with libel by the official of the Commission on Audit during that time. It was because the Guardian, weekly newspaper of Bobby de la Cruz, published a story telling that the ballots for the elections of Batasang Pambansa then were found in the house of that Commission on Audit. And because of that, they were charged with libel by this Commissioner on Audit. Where did Commissioner on Audit charge them? He filed it at the Tacloban RTC. So meaning to say, here came a situation wherein Bobby de la Cruz and all others were in Manila, Quezon City, but they were charged with libel in Tacloban City. So it was very, very far for them, and it would be very, very inconvenient for them. So the lawyers of Bobby de la Cruz and all others in The Guardian filed a motion to quash based on their allegation or argument that the Tacloban Regional Trial Court did not have any authority or jurisdiction to entertain libel case out of the same press release that was published in The Guardian. Because, number one, the jurisdiction based on Article 360 of the Revised Penal Code, you can choose from among, number one, if you are a public officer, you can file it in the RTC of the city or province where you were holding office at the time of the publication of the alleged libel. Number two, you can also choose in the city or province where the alleged libel was printed and first published. So meaning to say, you look at it, why did the law mention first published? Because there can never be second published, you can never be charged for the third publication, you can never be charged for the fourth publication. So that means to say, you can now see by the law itself, Article 260, that there is no such thing as multiple publication rule. The law that was made by our congressmen and senators during the time, they already look at the possibility that there might be other publications. But then, may I just state that if we will look only at Article 260, the Revised Penal Code, there is no such thing as multiple publication rule. Anyway, the case that was cited by the RTC and the Court of Appeals in Manila was that in Marcelo Soriano versus Ayak, the situation was this. I repeat, there was one press release made in so many copies, distributed by the PR man to all newspapers, to all weekly newspapers in Tacloban City, and to all newspapers in Manila City or Metro Manila. And ito in Metro Manila, it was the weekly of The Guardian that published it. So, that Commissioner Reynaldo filed a libel case against Bobby De La Cruz and the rest of The Guardian at Tacloban. So, as I said earlier, the lawyer filed a motion to quash or dismiss, or to quash or to reject the case because of the fact that the jurisdiction must be in the RTC of Quezon City. By the way, the problem with this is that the RTC of Tacloban was subservient or was yielding to the wishes of that commissioner on audit. And because that RTC was favoring the officer of the commissioner on audit, it resulted or compelled the group of the Guardian's newspapermen to file or to challenge the decision before the Court of Appeals at the time. And the Court of Appeals says that for every libel for every publication, there is one libel. What did the Supreme Court mean about it? The Supreme Court was saying that you cannot use the libel filed, the article published in Tacloban Daily, weekly, to secure jurisdiction just because the one that was published in Tacloban Daily, weekly, was the same in word for word as the one that was published in The Guardian in Quezon City. The Supreme Court, because they are of different newspapers, actually different names of dailies or weeklies, then every weekly has one particular separate libel. So you cannot lump them all because the editors in the Tacloban weeklies were not the editors in The Guardian of Quezon City. So that was the invocation by the Supreme Court of multiple publication rule. Meaning to say, the publication done by The Guardian can never be aggravated by adding the publication of other newspapers and to make them as one case. It's not. So, let us now go to number 2 case that was cited. In the number 2 case that was cited, as again, according to them, the source of the multiplication publication rule, they are again in mistake. That's a big sin by the Court of Appeals and the RTC of Manila. In the case of Montinola versus Montalvo, the news item, remember, the news item that was in controversy here was published in the November 29, 2019 na 2013 is 1913 issue of El Adalid. And then in the December 2, 1913 issue of El Adalid, the same item was published. So meaning to say, twice it was published. First, in the issue of November 29, 1913, and second, in the issue of December 2, 1913, in the same weekly called or named El Adalid. So, the Supreme Court said in this that the libel case out of the publication of November 29, 1913 issue is separate from the libel case that was published, although of the same story, on December 2, 2013 and 1913. So meaning to say, because what happened here was that the person who published this, was invoking that he should not be charged again because the one that he published in the December 2, 1913 issue is still the same copy as he published in the November 29, 1913 issue. The Supreme Court said, no, they are different because it's very clear. They are of different issues. They are of different dates, although the same weeklies. Okay? Now, so meaning to say, you cannot just say that there is publication rule, another publication on the part of Rappler. Why? Because they corrected only the spelling of the word evasion, A-V-T-I-O-N, which is wrong, to evasion, which is E-V-A-S-I-O-N. So when they corrected it, still, the date of publication is the same. And still, all other words, aside from evasion, are the same. So meaning to say, there was no new thing. And the issue is still the same, May 29, 2012. So, issue date is the same. And the posting is the same. And if you are a technical man, you can see the URL or the uniform resource locator or the link is the same. So, all others are the same is in aside from the word evasion and evasion. So, meaning to say, you can look at here evasion as the same meaning as evasion, that is T in spelling. But, although mistake in spelling, but in all others, they are the same. So, meaning to say, they are one and the same. The date is the same. So, meaning to say, only one publication that what happened. And there was no further damage that was committed just because you corrected the spelling. Okay, next is, the Court of Appeals cited the case of the lolo of Senator Tito Soto in the case of U.S. versus Vicente Soto, GR number 11067, decided by the Supreme Court on March 6, 1917. So, here, what happened, very clever. The lolo of Vicente Soto was very clever. What is involved here were two publications, but in the same newspaper, named Independent. In the first issue, Vicente Soto published a seemingly libelous article, but he did not name the persons to whom these alleged defamatory remarks were ascribed. Now, he published another issue, but this time, he published caricatures, and each caricature was now given that name. And that caricature clearly conveyed a message that they are connected to the first publication. The first publication here was done by Vicente Soto on 2 May 1915. The second publication, which is the caricature, as I said a while ago, was done on 22 May 1915. So, meaning to say, so what did the prosecutor do? They combined the two articles together to file one libel case. And the Supreme Court agreed with the prosecutor. There must only be one case for two issues. This time it is the reverse. Two issues, one on May 2, 1915, and another is May 22, 1915, but the prosecutor joined together the two issues of that newspaper named Independent to make out a case of one libel only. So that's the story. So meaning to say, you are now looking here at a situation wherein it is really wrong for the Court of Appeals to have used the multiplication publication rule in order to conclude that Maria Ressa and her reporter, Reynaldo Santos Jr., were guilty of libel committed against businessman William King. So that's it. So tomorrow, I'll discuss more about my dissenting opinion on the same libel case where Maria Ressa, who is our pride because she is a Nobel Prize winner, and Reynaldo Santos. Okay? Magandang umaga po sa lahat at bahala na po kayo. At sa ulitin, ay nais ko lang sabihin sa lahat na mag-ingat po tayo lahat kasi marami pang COVID. Ako po si Atty. Bertelli Catalunya Causing, Atty. Tuto Causing sa mga kaibigan. At ako'y nagbablog today. I am dedicating this vlog to my client, my good friend, and my fellow journalist, Percy Lapid. Sana ay nakikinig ka ngayon dyan sa langit. At ang tanging masasabi lang, magandang umaga, Persilapid!